Good afternoon, everyone. Is that Alstrom, or am I pronouncing it correct?
That's my last name. My first name is Julie. My husband and I um, share this device, and so it is just too weird for him to be in a Zoom call with Julie showing up. So that's why we chose to use our last name so that both of us and our grandchildren could also use it.
All right, then
Right.
welcome. Thank you
Thank
for
you.
joining us today.
Thank you.
Welcome, Miss Ostrom.
Hello, thank you.
And
You're
Julie, I
welcome.
just renamed you, so now it says Julie Ostrom, so we know who you are.
Oh, thank you so much, Mr.
Ma'am,
Black. I appreciate it.
call me Paul, please.
Okay, thank you, Paul.
So we're going to wait maybe another minute or two just to give everyone who's planning on attending a chance to join us today.
And Crystal, remind me, are these attendees from all across Georgia or all across Metro Atlanta today?
All Metro Atlanta.
Okay, fantastic.
So while we're waiting, if some of you want to just tell us where you're calling in from or joining us from, if you're in Clayton County, DeKalb County, Fulton County, that would be great.
All right, so I'm Julie, and I am now living in Decatur, Georgia, which is part of DeKalb County, although Decatorites would probably say it's its own unique entity, which it is. So I'm very happy to be participating in this event. I think I have a lot of questions that I thought I would have to be much, much older before I started thinking about these things, but that's not true.
Okay, well, hopefully we have the expert online today and he'll be able to answer those questions for you.
Okay, thank you.
And Julie, you're so young and gorgeous. When my clients are below about age 75, there's a lot of proactive planning we can do. So there's still plenty of time for you to ask these questions and get good counsel from me or anybody else.
Thank you very much.
Absolutely. And I don't live in Decatur. I live in Clarkston, right outside Decatur, because Clarkston is literally half the cost. But my joke about Decatur is that it's the most liberal, expensive, and educated place in Georgia. And I'm okay with two of those. The expensive part is why I don't own a house in the city of Decatur.
You're exactly right. I graduated from Decatur High School in the last century and lived many other places before my husband and I moved back to the area so that we could be closer to our daughters and a lot of our grandchildren.
Right.
And so the local one, we're renting an apartment right now. The local kids are also living outside of the city limits of Decatur for the very reason you just mentioned. It's a real shame.
Well, it's a great place to live, but my wife and I have been married 3 years and no kids yet. So paying 10 or 12,000 a year in property taxes just didn't really appeal to us.
No.
If you have kids, it is an amazing place because of the great schools. But otherwise, a lot of my clients, as they retire, they move elsewhere because it's so expensive to pay property taxes there.
That's correct.
Okay, it's about 1:35, so we will go ahead and get started. And as any other participants come on, we'll go ahead and let them in. But just for the sake of time, we'll go ahead and get started. So I would like to say good afternoon, everyone. Welcome to our Thriving After 60 series. My name is Crystal Finley, and I am actually one of the local Kaiser Permanente Medicare specialists here in Georgia. And for those of you, I know all of you know that May is Older Americans Month. And this year's theme is Age My Way. And many caregivers and family members encounter healthcare challenges as they're trying to assist family members through things like healthcare directives. So we thought it would be great to invite an elder care attorney to answer questions on estate planning and some of your questions that you might have. So I'm excited to introduce our speaker today, Paul Black of the Law Office of Paul Black, Elder Law and Estate Planning. I will ask that you hold your questions to the end of the presentation, but please, by all means, if you have a question, you can go ahead and type that question into the chat box, and then Paul will answer those questions at the end of the presentation. So what I will do is while I introduce him, I'll go ahead and read a quick bio for him. And it basically, let's see here, is Paul experience as the son of two parents with big health challenges is what led him to the work he does today. His mother wrestled with early onset Parkinson's disease for 27 years before her death in July 2016. His father suffered a major stroke in May of 2001 and lives in assisted living in Atlanta. Paul's active involvement in his parents' care gives him firsthand knowledge of the challenges that many caregivers and family members face. After finishing law school in 2010 and completing a National Elder Law Fellowship in 2011, Paul launched his own private practice. Today, Paul finds great satisfaction in serving clients across Georgia who need help with elder law issues, including Medicaid and veterans benefit planning, estate planning, such as wills, trust, powers of attorney, and healthcare directives, uncontested probate court matters, including estate administration and guardianship, and conservatorship petitions, and special needs trust planning. Paul has been named as a super lawyer's rising star in the area of estate planning and as a member of Georgia's Legal Elite by Georgia Trend magazine. He is a native of Albany, Georgia, and currently resides in Clarkston, Georgia. He has two offices. One is in Decatur, that's his main office, and one a Dunwoody office. So I introduce to you my newfound friend, attorney Paul Black.
Crystal, thank you so much for that generous introduction. And just a reminder, all of those qualifications don't really mean a darn. It's really, you're only as good as the last client that you served. So because we serve mostly older and often vulnerable clients in my practice, whenever we hire a new employee, I remind him or her, hey, you're only as good as the last person you talk to and the last person you serve. So don't ever let any of that, give you the big head. But the presentation today is really designed to give you guys as attendees a good overview of topics that you should be thinking about. I should warn you that I taught high school before I went to law school. So I'm used to rooms full of energetic 14-year-olds or 17-year-olds who want to bust out and go off and do anything but sit in front of me. But if you have questions, I ask that you save most of those towards the end. And if there's anything, during the presentation, if I ask, I'll probably invite some interaction because we're a small group today. But if your questions are really specific to your situation, I'll probably generalize those and make those relevant for everyone so we don't air your laundry in front of everybody else. Because some folks try to do that, and I try to put a damper on that to keep their private stuff private. And yes, there was a reminder just now from Crystal. Feel free to put your questions in the chat as well. All right. So enough about me. Let's actually get into the meat of the presentation itself. So today's presentation, let me start my slideshow. Today's presentation is actually called 10 Tough Questions. It is designed to be a self-assessment. You don't have to keep score as you go through this, but if you want to keep score, by all means. The goal here is not to compare your situation with anybody else's. The goal is for you to self-assess, where am I on this question? Do I have a good plan? Do I have nothing? Is there room for improvement? That's why we're here today. All right. So here I say 10 Tough Questions is designed as a plain English presentation to help people assess where they stand on common questions that arise in the areas of estate and incapacity planning. I hope that you find this to be helpful, and I welcome your questions and feedback. So we just had 2 new attendees who rolled in. All right. So the first question that I often get into, do I take ownership of my health? That's kind of a weird question for a law school graduate to ask you. After all, I was too dumb for med school. Why do I care what's happening with the health of anybody who walks in my door? The reason is most conversations I have with clients are centered around some major healthcare event, a fall that breaks mom's hip, dad having a dementia diagnosis and having a very bad short-term memory, mom or dad or Aunt Sally having a stroke. These are all examples that I deal with every day. And so a lot of conversations that elder law attorneys have are about your health or that of someone in your family. A few people a year I see really don't do anything proactive about their health. If we read through answer choice A, I have some pretty major health concerns, but I'm not proactive. I don't really take ownership of my health. I see that a few times a year. And my job there is to be the gentle coach and say, you know, you really should go and take care of these things and take better care of yourself. It's often the caregiver spouses who are the worst because they're taking care of everyone but themselves. We see that all the time. A lot of us would be in answer choice B. We do a decent job taking care of ourselves. We see our doctor regularly, but we could do a better job with diet, exercise, and educating ourselves about family risk factors. Some of us, especially if we're not overwhelmed by raising kids or taking care of, of older adults in our family, we're answer choice C. We take good care of ourselves. We exercise as much as we could. We've educated ourselves about family risk factors. We're being pretty proactive. That's a good place to be. Okay. Then there are the real nuts like me. Our family history is so riddled with certain healthcare issues that we don't really have a choice. If we're not very proactive, bad things are going to happen. Paul, how do you stay so thin? Well, let's see. 3 of my 4 grandparents had heart attacks. One of them died on the operating table back in '85 before, open heart surgery was really that well advanced. 2 of them had quadruple bypasses. If I'm not particular about my diet and my lifestyle and my numbers, I've already seen what that other path looks like, and it ain't pretty, and it ain't a recipe for a good quality of life. So for me in my 40s, I always go and get my cardiac calcium score test every 5 years so I can figure out, is my risk factor for a heart attack or for a clot increased? I really stay on top of those numbers because in my family, I don't really have a choice. Answer choice E is just here for laughs. I am immortal, gorgeous, and wealthy beyond belief. None of this stuff matters to me. I'm not certain why I'm even taking this quiz. So I have a lot of clients who are very vibrant in their 80s and even their 90s, but I have yet to meet an actual vampire. So all of us are mortal. These questions are actually relevant for all of us. Yesterday, I met with one of my clients. I first started working with her and her husband back in 2016, which would have been 6 years ago. And now she's 80 and she's a little stooped over, but she's got a great haircut and she still walks around the block many, many times every day. And I could not keep up with her down the hall. That is where I want to be. So these little things about healthcare can become big things over time. And again, probably 2/3 of every conversation I have with older clients center around a diagnosis or a recent health event like a heart attack or a stroke that is life-changing that we have to respond to. The second question is, who will help make decisions for me? One of my only mantras in my practice is your people are your plan. I just got off the phone a few minutes ago with a new client. She just got tenured as a professor or just received tenure as a professor. She does very interesting research. She's brilliant. She has an incredible body of work. The one thing that she doesn't have that we're building on, she doesn't have a lot of people in her life who are able to step up and make decisions if she's not able to do so. So answer choice A, I am socially isolated. I do not know who would step up to take care of me if I were not able to do so. Since 2/3 of my clients are seniors, it may not surprise you that probably every 6th client that I see is a solo senior. They don't have a spouse. They don't have adult kids, or their adult kids are not involved or estranged or live halfway across the world. We have to build a team around them. Another term that you'll often hear thrown around, Paul, what does it mean to be an elder orphan? An elder orphan to me means that someone is older, often in their 80s or beyond. They are vulnerable and the wolves are at the door. People are already trying to steal money. Bad things are already happening. We've got to build a good team now, because if we don't, then things are going to get very bad very quickly. And that's not me being a fearmonger. That's kind of an axiom of human nature. Where there is weakness, predatory behavior is never far away. And my clients come of all, they're of all backgrounds. They're lovely people, rich, poor, young, old, gay, straight. I see everybody you can imagine. The one thing that never ceases to amaze me is where someone is vulnerable, there's often bad behavior from someone trying to take advantage of that person's situation. And ironically, a big part of my job is to separate the caregivers from the thieves and make sure we have a good team around you. Answer choice B, I have some close friends or family who would likely step up for me, but we've never really discussed it. Well, that's not much of a plan. We can do better than that. Answer choice C, I have close friends or family who will step up if I cannot do so. We have discussed it, but not in detail. Oh, Paul, my sister, my brother, my neighbor, they'll step up for me. We've talked about it. Okay, that's a start. You've got good people, but let's look at answer choice D. I have close friends and family who will step up to make decisions if I cannot do so. There are documents in place that empower each of these people in the appropriate order to make decisions for me. I have discussed my wishes with my decision makers, and I've shared documents with them as appropriate. So, dumb question. Which of these answer choices is the best? Obviously, the last one by a mile. That part of my job is to get anybody I serve to D. For my clients who are solo seniors, we literally talk about where they're going to go and meet people, or do they have friends they could ask to serve in these key roles, because I don't want any client to have a single point of failure. If you talk to any engineer, anybody who designs systems, you never, ever have a system where one thing failing can make the whole thing fall apart. That is the definition of bad planning. It's also true with the human element. You need people, not person. You need people to be part of your plan, because your people are your plan. The third question, who will make healthcare decisions when I cannot do so? I'm going to overshare from my personal story. October 13th of 2013 was a Saturday. My grandmother, Frances Black, was 90 years old. She lived down in Albany where I grew up. I grew up about a mile away from her. I was over at her house all the time growing up. We were very close. She was suffering from a urinary tract infection, which for a 90-year-old woman, if you've taken care of anybody at that age, that's a really common thing for a 90-year-old to have, especially a woman. The problem was that the oral antibiotics that her physician had prescribed, they weren't exactly making it better. I talked to her on Tuesday. She initially saw her physician. I talked to her on Thursday. Her speech is more slurred. And I call the doctor. I say, Dr. Dorsey, can you see her again? Can you squeeze her in? I know you're busy, but I'm not really convinced this antibiotic is doing it. He said, Paul, just give it a couple of days. We'll see where she is. I drive down on Saturday, 2 days later, to give my grandmother's caregiver a couple of days of break, because she's been working for about 36 hours straight and she's exhausted, and I wanted her to be able to go have a life. Within 2 hours of my arrival, my grandmother, Frances, her eyes are bugged out. She can't drink the water that I'm giving her without coughing. Her speech is really garbled. I do what any loving, person would do. I call the EMTs and I say, my grandmother's in distress. Please bring an ambulance. I think something really bad is going on here. We get her to Phoebe Putney, which is the big hospital in Albany. She's dead 18 hours later. Her urinary tract infection was undertreated. It became massive septicemia. The oral antibiotics were not nearly enough. It happened really, really fast. But here's the good news. Frances was outspoken. She had told all of us in our family who had listened for many years, when it's my time, get out of my way. I do not want life support. I do not want heroic measures. I want to be in heaven with my Lord and my husband. Get out of my way. And so when I had to make the phone calls that Saturday night in the wee hours of Sunday morning to family, all over Georgia and Florida, and say, here's what's happening with mom and grandmother. Are we on the same page? I had the moral authority to make decisions, because the grandmother had told me many times, this is what I want. This is why. She told all of us who would listen. I had the legal authority to make that decision from the healthcare directive. But here's the weird thing. I wasn't the first person listed on Francis's healthcare directive. I wasn't even the second. My dad was first. He'd had a stroke many years prior. He couldn't serve. My uncle Collier, who's tall and skinny like I am, was having major, heart issues. He couldn't serve. He was in Jacksonville. It fell to me as the third person, the grandson who happened to be there in Albany that day to make those decisions. Thank goodness my grandmother had the healthcare directive in place, but equally, thank goodness she told all of us exactly what her values were so we would know what would guide us in that decision. And the reason I share that story is I spend a lot of time with anybody I serve going through the healthcare directive itself, making sure they understand the document. We also talk about who's on their team because this document is very often used in a crisis. You want people who are able to keep their wits about them in a crisis, people who are able to communicate clearly, people who are going to hear and heed your values, but who also are able to exercise their own judgment. Bluntly, that's not everybody. You may have an adult daughter or son who's amazing in some ways, great as a parent, amazing at, at saving money or investing, but put them into a crisis where someone's life is on the line, they may or may not be the right person. So that's what item 3 is about. Do you have documents to empower people to make decisions? And have you actually had the conversations with these people about what you want? And by the way, I had a repeat of this in July of 2016. My mother had a very rapid decline her last year. She was only on hospice for the last 9 days of her life. But my mother, Edith, like my grandmother, Frances, her mother-in-law, she was very outspoken. My mom had communicated to all of us what she wanted. And when I was the healthcare agent, I talked to my sister, I talked to my mother's siblings. We were all on the same page. We knew what needed to be done. And there was no guilt or hesitation because she had given us that moral authority to make that tough decision. So I can't do all this for you. I cannot have these conversations with your decision makers who are on your team, but I'm happy to facilitate those. And I want them to have what I call the gift of clarity. I want you to give to your decision makers what my grandmother Frances, my mom Edith gave to me, and that is clarity about what you think you might want. And a big part of my job is to help people get that by talking through these situations. Okay. So as we get to the second slide here, hopefully you have a healthcare directive. Maybe you have a DNR or a POLST. I won't get into those. Those are more specific documents that are really for end-of-life care. But even if you are a Buddhist monk and you've taken a vow of poverty, you need a healthcare directive because you're still possessed of flesh and blood and a life. And you probably have some opinions about how you want things to go down if you cannot survive without that end-of-life care. So let's look at answer choice D. I've completed an advanced directive for healthcare, and I have discussed my end-of-life planning wishes with all of my agents. I have named successor agents if the first name agent cannot serve. All of my agents are ready, willing, and able to serve. It doesn't matter who you are. If you leave my practice, that is where I want you to be because that's what everybody deserves. Well, Paul, do I need to hire you to get a healthcare directive in place? No, you can actually find the Georgia Advanced Directive for Healthcare online free of charge. Well, Paul, why do people pay you to do this as part of their planning? Because people don't like discussing this and they need someone to walk them through the entire process, and it dovetails with their will, with their financial power of attorney. It's part of that conversation, and we do a very thorough job making sure that these things actually work together. Just to be clear, Georgia has used the same advanced directive for healthcare form since July of 2007. If you look online, it ain't hard to find, but it's what I call an iceberg document. 90% of the substance and the power is below the surface. A big part of my job for anybody I serve is to walk them through all of the nooks and crannies and make sure they understand the power they're delegating and that this is a fit for what they want. Who will make financial decisions for me when I can't do so? Hopefully nobody says, I don't really have anything in place. I'm an A. I don't have any documents in place that empower others to make decisions if I cannot do so. Well, newsflash, if you're married, You may think that you have automatic authority to make decisions about your spouse's separate assets. Believe it or not, you don't. One of the biggest reasons to have a financial power of attorney is without that document, your spouse cannot make decisions about separate assets that you own. If you are single or widowed or partnered but not married, then obviously the same logic applies. You've got to have a financial power of attorney to empower others. Okay, here's where we look under the hood. Is this a well-drafted document? You might laugh to hear that I'm probably going to be teaching as an adjunct at Georgia State University College of Law next year. No joke, I have a folder full of documents called bad drafting that I'm saving as examples of what not to do, because a lot of poorly drafted documents cross my desk. I'm not that different from a car mechanic or a plumber, because a lot of things I see, I'm like, well, whoever did this last really jerry-rigged it and it worked for a couple of years, but now we're gonna have to fix this and do it the right way. And so a lot of documents I see, they have gaps. They're really old, they're rusty, things need to be replaced. My job is not to sell you paper. My job is for you to have a functional plan. And sometimes there are things that have to be fixed. Maybe you've signed a detailed document. You understand the authority. That's a good place to be. I want you to be down here at answer choice D. I've executed. I've signed a detailed financial power of attorney. I understand the authority that it grants. I have named successors if my first agent cannot serve. Everybody I've named is totally trustworthy and they're ready and willing and able to serve. Well, Paul, what if the nephew or daughter that I name, what if they turn the tables one day and they start stealing money from me? What do I do? Well, I've had that happen a couple of times over the past 12 years. I have that client come in as quickly as possible. We revoke that existing POA. We record the revocation. We let the bank know. We call all the custodians and let them know. We try to stop. There we go. It looks like I was muted for a second. The reality is that giving someone authority under your power of attorney is a huge deal. You've got to name the right people, because otherwise it can be a license to steal from you. When we go through this document, when I meet with clients, we talk about how powerful it is. We talk about, do they really want to grant this degree of authority? Are there certain things that are not a good fit? We talk through all of that to make sure that this is a good fit for them. All right, where do I keep my important documents? Well, answer choice E is easy. Paul, I don't have any documents. There's nothing to lose. Awesome. Well, that's a great starting point. Answer choice B, and I hear this all the time. I think my loved ones be able to find my documents, but they may have to dig for a little while. It is a joke with my wife and I, with my paralegals and my, my admin, at least once a quarter, I say, Paul's had a stroke today. Where are Paul's documents? They're like, the documents are up there on the top shelf. Your name is on it. Stop bugging us about this. We know exactly where your documents are. Where are Paul's passwords? Paul's passwords on this secure web page we can view here in the firm. So everything you have, you need your loved ones to be able to find. If they can't find it, it doesn't do any good. Several times a year, we have to petition a probate court to get permission to open a deceased person's safety deposit box, just to see if there is a will or if there are other important documents or assets inside that box. Not a fun thing to have to do. If we can avoid that, we want to do that. So hopefully you guys are answer choice C. All my decision makers know where my hard copy important documents are located. I have digital copies of my documents, and the most needed documents that I have, like my healthcare directive and my financial power of attorney, those are in what I call a grab and go location. They're not in your safety deposit box. Last time I checked, banks are open 36 hours a week and not on Monday when they want to be open. So that's a bad place for immediate documents. Have those grab and go documents in a grab and go location. Your will, your trust, those can be in a more secure location. We're not running to the hospital with a copy of your will. If any loved one of yours ever shows up when you're in the hospital with a copy of your will, they're either after your money or there's something else going on. If they show up with your healthcare directive or your financial POA, that's because they love you and they want to help you take care of these things. So keep the urgent documents in an easily accessible place. I won't ask for a show of hands because I can't see all of y'all today, but a lot of us are still working stiffs and have to get up and go to work to pay the bills. My dad was a very good disability and civil rights attorney. He had a great reputation in South Georgia. My dad went from arguing before the 11th Circuit Court of Appeals in Atlanta one week to not being able to tie his shoelaces or talk the next week after having suffered a major stroke. He had disability insurance, just didn't have enough. So he had disability insurance through age 65. That's huge. Who bridges the gap between dad's income and dad's cost of care now? I do, because that's what any loving, financially capable, adult child would do. But for those of us who are working, having disability insurance is a big, big deal. By the numbers, about 1 in 4 of us will have some sort of disabling event during our work life. If you are a pencil pushing desk jockey like I am, the odds are a lot lower. But a lot of clients I serve, they're men who've worked in warehouses for decades, and their back is not as strong at 62 as it was at 22. And there are jobs out there where their risk of injury are way, way higher. This is a thing. So anybody I serve, I want to talk about the nature of their work. I want to talk about if they have long-term and short-term disability policies in place. A lot of these policies, by the way, they don't replace all of your income. They just stop the bleeding. They might replace 60% or maybe 2/3 of your earnings. But if you don't have savings of your own, it's still going to put you behind the 8 ball. In my dad's case, my dad had done a decent job saving. Keep in mind, he put 2 kids through college. He was in his 50s. I was just finishing college when he had that stroke. My last year tuition was basically free. The first 3 years, not so much. So in my dad's case, he had some savings, but over the 10 years after his stroke, he had to spend his savings to provide for care, because care, throughout the day was not a cheap thing to purchase, even in Albany, Georgia. Okay. Hopefully, those of you who are of working age have some disability policies through work. If you've never looked at them or haven't looked at those in a while, I encourage you to dust those off and look at those, because that's what we do. We play what if. What if I had a disabling event tomorrow? Is my spouse going to be able to pay the bills? Do I have money to take care of these things? A lot of you here today, because you're over 60, Paul, don't overthink this. You're going to answer choice E. Paul, I no longer need disability insurance because, praise Jesus, I no longer need income from work. I am done. I don't get up and go work for the man. I am retired. Thank you very much. That is a great place to be. I hope to join you in about 17 to 20 years. But until then, those of us who still work need to have disability insurance in place. What about paying for a long-term care? Hint, it's expensive. And we're going to talk through some of the numbers today. A lot of people I serve say, if I have to pay for it, Paul, whether it's, a care at home or living in assisted living or memory care or nursing home, I'm just not going to be able to do it. I don't have the money. I hear that all the time. Some people say I could pay for a couple of months, but after that, I am financially tapped out. Some folks say, Paul, I've done a good job. I can pay for a couple of years, but if I'm paying $3,000, $4,000, $5,000, $6,000, $7,000, $9,000 a month, I can't pay for that forever. I'm going to have to get help paying for care at some point. Here are recent numbers. Genworth, you may know, is an insurance company. They're an offshoot of General Electric. They do a really good cost of care survey across the country every year. And these numbers, by the way, are pretty darn accurate in my experience. Paul, what does it cost for adult day care for a loved one? The answer here in Atlanta right now is about $16,000 a year. That's not cheap. Wow. Look at the numbers for assisted living. $50,000, almost $51,000 a year. Take someone like my dad, who's paralyzed on his left-hand side. Mentally, he's so sharp on attack, and he can run my business and tell me exactly what I need to do. He will still, run me. But he needs help bathing and dressing and toileting and sometimes transferring. He requires a lot of help. His care is more than $5,000 a month. That's why I go into pocket every month to help him pay that bill. It's expensive. And then, holy cow, nursing home care. A semi-private room, $88,000 and change a month. A private room, nearly $100,000 a year. I'm not a fearmonger, but I am a realist. And a lot of people I talk to have sticker shock when they find out what the cost of long-term care for themselves or a loved one is. But if we're able to plan ahead and have a long-term care insurance policy or have savings, or hopefully a combination of both, we have some prayer of being able to pay for very expensive care. This is one of my favorite cartoons, by the way. I've got to read this to you. This is Myrtle and her friends who are here in assisted living. And Myrtle says, "I so look forward to having my family visit me. Making them feel guilty for putting me in here is my only pleasure in life." And the reason I laugh about that is when I go see clients in assisted living, the number one thing I hear is, "Paul, I don't want to live here, but insert reason why someone is here. I've had a series of bad falls. My dementia progressed to the point where I could not live safely at home. I was starting to eat raw chicken out of the fridge. That was kind of a problem. I had to remember to cook food." So these are all real stories, but paying for a long-term care is very expensive. The good news is that I don't sell long-term care insurance. I have zero financial incentive. If you have a policy, I want to look over it and pop the hood and make sure everything is where it should be and that you understand it. If you don't have it, but you're looking at buying it and you're a client, I'm going to review those policies with you. We're going to talk through the pros and cons and have a beauty contest so you get to pick the winner. So long-term care insurance, it's a pretty upper middle class thing to have. But man, if you can afford it, if you can set aside the savings, it can be a godsend later in life, because long-term care, as we've seen from those numbers in the last slide, it ain't cheap. What about life insurance? Do I even need it? And our cartoon here is a classic from a New Yorker. Life insurance, God forbid, just in case something should ever happen to you. And the caveman is walking outside, to a world full of dinosaurs. I want to remind y'all who are, anthropology majors. Yes, I know this cartoon is historically incorrect. Homo erectus and the dinosaurs did not coexist. I know that, but still a great cartoon about life insurance. So a lot of you who are older say, "Paul, I don't need life insurance anymore. I'm good. I'm going to be fine." You guys are already a slide ahead. Be patient with the rest of us. A lot of us still need life insurance. And the reason we need that is because we don't have enough savings on our own to pay for all the things we leave behind. If you've paid for tuition for a child, and I know many of you have, if you've paid for, help pay for a first house, if you've paid off a mortgage, all of these things take money. Not all of us are made of money. Life insurance for a lot of us is essential as a cushion, as a source of funding. My wife and I, Nadia, were married back in July of 2019. So it's been almost 3 years. First marriage for both of us. But the month after we were married, after Nadia and I had signed our financial powers of attorney and our healthcare directive so that I can make decisions for her and vice versa, I said, "Nadia, I love you, and we're going to take out life insurance policies on each other. Mine is payable to you, yours is payable to me, so that if one of us passes away, there will be no financial hardship for the other spouse." What a perfectly dorky, awful thing to do. Nothing says "I love you" like the gift of life insurance for a spouse. But the reality is, in my day-to-day work, I see firsthand how important it can be to have life insurance. And until I'm a wealthy man down the road, there's going to be a life insurance policy in place to take care of Nadia if I pass away, or to help take care of my expenses if she passes away, so that we will be okay. Now, as I've worked and saved and put away more money, the life insurance policy becomes less relevant. But for most of us in our 30s, 40s, and 50s, and sometimes even of our 60s, life insurance is a big deal. A lot of clients I serve who are at the lower end of the income or asset spectrum, a $10,000 life insurance policy is often the only money we have to pay for their funeral or cremation or burial expenses. And so a little life insurance for a person of modest means can really go a long way. Okay, a lot of you are going to say, "Paul, I'm down here at F. I don't need life insurance. I've either prepaid for my funeral, I don't have anybody dependent upon me, or I already have enough assets. Thank you so much." That is a really good place to be. The general rule in my practice is that when I'm dealing with younger clients who are still raising kids in their young children or teens or 20s, life insurance is important. But once we hit our 60s and our mortgages are mostly paid off, and we don't have young kids who we may be helping with their expenses, that life insurance policy may recede in its importance. Now, can anybody decipher for me what this drawing at the top of this slide actually means. You can't take it with you. You've never seen a U-Haul behind a hearse. If you have, that's awfully weird. So this slide it says, I know I can't take my money with me when I die, but will my lack of planning force my loved ones to go through probate after I die? A lot of you who were here today have probably already been through the probate process. I know that you can't wait to go through it again. The process itself is not evil. It is not complicated, but it's full of paperwork and hurry up and wait and lawyers. Yuck, who wants to go through that? I do enough probate in my practice without having my existing clients go through it. If I'm helping anybody I serve plan proactively, we're going to look over every asset you have and make sure you've named beneficiaries and backup beneficiaries. We don't want anything to go through probate if it doesn't have to go through probate, because probate is not a pleasant process. Having said that, I have a lovely relationship with the staff at Fulton County, DeKalb County, Gwinnett County, name a probate court here in Metro Atlanta, and many of those across the state. We have a good relationship, but the less we see of them and them of us, the happier all of us are, because that means that my practice has done a good job helping you name beneficiaries so that nothing has to go through probate. Well, Paul, what about real estate? I can't name my kid on my house, or if I could, I don't want to. She's 32. She has so-so credit. Adding my daughter to my deed is one of the dumbest things I could do. Yes, you are correct. As my clients get older, especially as they approach 70, if they have no plans to sell their home place or other real estate, that's when we start talking about putting that real estate into a trust, most often a revocable trust, also called a revocable living trust, to avoid probate down the road. The goal here is not for me to sell you paper. The goal is to minimize headache and expense and other friction down the road after your death, as your loved ones or your trusted decision makers are dealing with assets. One issue that I see a lot of deeds that don't include survivorship. If Jack and Jill own a house in Georgia and the deed just says Jack and Jill, when Jack passes away, because Jack usually dies earlier, let's face it, women survive men by an average of about 7 years. If Jack predeceases his wife, Jill has to go through probate to get Jack's half of the house. But what if that deed says Jack and Jill as joint tenants with rights of survivorship? Those 7 magic words, as joint tenants with rights of survivorship, those avoid probate upon the death of the first spouse. That's huge. Putting property into a living trust goes one step further. That can avoid probate upon the death of the surviving spouse. And that's an easy thing to do now. It's not that much more expensive to have a trust-based plan versus a will-based plan. And if it saves headache and money down the road for your loved ones, we should think about that. Disposition of assets upon my death. We're going to talk through this. I've named beneficiaries for my assets. I've confirmed this by reviewing all beneficiary forms for my accounts. Nothing, Paul, is going to slip through the cracks. And Paul, if I have real estate, it's either titled as joint tenants with rights of survivorship, or it's titled into a trust. Newsflash, if you're thinking of naming anybody other than a spouse as a co-owner on your real property, your real estate during your lifetime, not so fast. That person, if not your spouse, doesn't get what's called stepped up basis. Long story short, you can cost them a lot of money in taxes when they go to sell. That same property, if the transfer occurs upon death through a survivorship deed or through a will or a trust, it still gets stepped up basis. That means they're paying a lot less in taxes when they go to sell the house down the road. My general goal for everybody I serve, whatever your background, I want to minimize headache and expense down the road. That often requires a little more attention to detail and a little more complexity now, but I'm not a fan of complexity for the sake of complexity. I'm a South Georgia boy. I want things to be simple, but no more simple than we can get away with to avoid headache down the road. All right, every third family I serve has an adult child or a niece or a nephew or someone, some beneficiary who's either young and dumb or bad with money or has a drug or alcohol issue or a shaky marriage, giving money to these people outright, not always a great idea. How do we plan for that? Well, we include language in a will or trust that specifies if this person is on means tested benefits like Medicaid or food stamps or public housing or SSI, this special needs trust is going to apply to them. Boom, it's already there, ready to inflate. If money goes to a beneficiary who has a drug or alcohol issue, this sounds crazy, your trustee can have that person tested, and that beneficiary with that drug or alcohol issue has to be clean for a year before they get money into their paws. Why do we do that? So we're not pouring gasoline onto a fire by giving money to someone who has a known addiction or alcohol, or drug or alcohol issue. That's one of the dumbest things we could possibly do. Paul, what about people who are in a shaky marriage or who are going through some sort of business breakup? The money doesn't belong to your beneficiary until it is in their bank account. As long as it stays in your will or in your trust, it doesn't yet belong to that child or beneficiary. That plus what's called a spendthrift clause, that's language in your will or trust that says this money doesn't belong to my daughter, Donna, or my son, Sam, until it's in their name. That can protect your beneficiary from their third-party creditors. If they're going through a divorce, if they're going through a business breakup, nobody else can put their hands in a cookie jar and take that money until it's in that beneficiary's bank account. That's basic good drafting. Every well-drafted will and trust includes this, but it's still a huge deal because it really protects your beneficiaries. You can't do that with your creditors. You can't say, well, Georgia Power, I don't want to pay you guys this month. That's okay. Can you protect your beneficiaries from their creditors? Totally. And this is one of the ways we do that. We talked about substance abuse. Probably every third or fourth family that I serve has somebody who falls into this category. That's a very common issue. My job is not to judge you. My job is to help you build a good plan. We also talked about special needs language. Probably every third or fourth family I serve has a spouse or a grandchild or someone who has a disability or means tested benefits. The special needs trust protects that person's eligibility for those benefits. Not doing so is one of the dumbest things that I could do as an attorney. I want to protect the benefits, even if we don't know about them yet. So we have language in your will or trust that doesn't inflate and deploy unless it's necessary. That's smart. All right, I'm going to stop bumping my gums and let you guys ask questions. I'm all ears.
Okay, Paul, I'll start off real quick.
Yeah, go for it.
What if you have, if there are multiple siblings and when it comes to the healthcare directives or when making a decision on the parent, how do you handle that? What do you do about that?
This is a great question, and we have a couple of options. First, let's talk about healthcare decision-making. Here in Georgia, I have many clients every year who want their adult kids to act together in making a healthcare decision if a client cannot do so. The two options we have for that are really simple. We can give your adult kids concurrent authority where they can act together. We can give them co-independent authority where they can act separately, but they're encouraged to act together. Or the most obvious choice, we can name those decision makers to act in series, one after the other. And for the record, I have dozens of clients who pick each of these options every single year. I've had many of them use these healthcare directives in a crisis. I know this language works. It's battle tested with providers all over the state. For healthcare in Georgia, there is zero issue with naming more than one person to serve at a time to make healthcare decisions for you. The obvious caveat, those people had better be able to see eye to eye, because in naming them to serve concurrently, you are absolutely creating potential for conflict. And if they're not on the same page, that's going to result in an impasse. So you've got to be careful about the potential for conflict. Now, let's talk about financial decisions, because my answer here is radically different. In Georgia, it is perfectly legal for you to name multiple people to serve as the agent under your financial power of attorney. However, that is one of the dumbest things you can do. Why? Try to walk into any Bank of America or Wells Fargo or other branch and say, hey, my name is Sally and my daughter's Jack and my daughter, Dawn and my son Sam are here as my co-agents under my financial power of attorney. That teller and the bank branch manager are going to look at you cross-eyed and say, Ms. Smith, legally you can do this, but we ain't taking direction from both of these individuals at the same time. Please pick one to serve in front of the other. Please put them in series. Just because you can name them together doesn't mean we're going to accept that document. So in general, where we're naming people to make healthcare decisions, yes, under the healthcare directive, we can absolutely name agents to serve concurrently or co-independently. But for financial decisions, naming people to serve at the same time while legal in Georgia is a bad idea. Well, Paul, what about co-trustees? Same caveat as last time. If they see eye to eye, how lovely. If they don't, you are creating a logistical impasse, and I want to help clients avoid that.
That was great. Thank you. We know that money can divide a lot of individuals.
And money also, and it sounds very jaded of me, but money brings out bad behavior. I have a client I went to go see in Kennesaw Hospital on Friday who's been in an abusive marriage for about 37 years. Long story. When the husband found out how much money was being made available to her, he started lying and cheating and trying to kill her off, and crazy things happened. So if I seem a little overzealous in trying to protect clients, is because my practice is informed by a lot of crazy worst case experiences. I want to help people avoid those crazy experiences by building a good team around you and having these what ifs taken care of.
Okay, Miss Evans, I think she wanted to ask a question.
Right. 2011, my father passed.
Yes, ma'am.
Mother had Alzheimer's. So
Okay.
we changed the deed where the four of us was put on the warranty deed for the house.
Right.
And she had survivorship. 2015, mother passed.
Right.
So I think we updated to deed, for the property tax thing. And so it had to show that my sister, who is special needs, she lives in the family home.
Right.
But now my brother has passed. So is there anything we need to update on the warranty deed? I'm almost like I'm afraid to touch it, because I don't want to open up a can of worms.
Ms. Evans, thank you for this question. I'm really glad you asked this because we deal with this every single day. Let me walk you through what did happen and what should happen. So dad died in 2011. Mom died in 2015, correct?
Mm-hmm.
Did either mom or dad die with a will?
Yes.
Okay, so someone presumably opened dad's estate back in 2011. What percentage of ownership on the house did mom get when dad died in 2011?
She just got survivorship because she had dementia.
Okay.
Her name was not even on the deed. Her name wasn't on the deed.
Okay, so here's how that should have worked.
When they bought the house in 2015.
In what year?
But it was in 1955 when they bought the house.
Okay.
I don't believe Dad put her name on the deed.
All right, I'm gonna knock this out of the park. You ready? When mom and dad bought the house in 55, there was no survivorship language. That did not exist in Georgia until 1978. A lot of attorneys are still too dumb to use survivorship language. Survivorship language is not common since about the year 2000. Dad died with the will. Dad's will was an I love you will that left everything to mom. When mom died in 2015, though, Miss Evans, did she leave a will?
No.
Okay, mom died intestate. You and your siblings, intestate means without a will. You and your siblings all get an equal slice of mom's house. Your sister, who has special needs, how old is she right now?
72.
Okay, because your sister is over the age of 65, this is weird. Federal law says we could still put your sister's slice of that house into a special needs trust, but we would be penalized for doing so because she's over 65. But I have backups. Who lives with your sister with special needs and helps provide care for her?
No one. She can take care of herself. I just do the financial decisions for her. And this
Right.
year I became her power of attorney.
Okay. Does your sister live in mom's house of which she has fractional ownership, that 1/4 share, for example?
Yes.
Okay. That is her home place.
She
That
lives
is-
in the family house.
Okay, that family house where your sister, who's 72 with special needs, lives, it is not a countable asset for her Medicaid or SSI eligibility determination purposes. She can apply for any benefit under the sun, and that slice of the house will not count against her. However, because she is 72, which last time I checked as a liberal arts major is more than 65, we can't fund a special needs trust because she's too old. So what do I do in her case? I review the power of attorney that empowers you to serve. I review her healthcare directive. I make sure she has really good, and these are basic documents, but I want to have a really good documents with a really good team. And then I want to figure out, is she getting every benefit she can? If not, we'll help her get this. That's how I would respond to this situation. So it's really not about mom and dad's estates at this point. It's really about protecting your sister and making sure she has a good plan, and then maybe working with other siblings on the same issue as well.
Okay, but remember now, with the house, the warranty deed that we have, all 4 children are on there. But
Right.
my brother has passed. Do we have to change the warranty?
Okay, here's the frustrating answer. Because your brother was a co-owner, did the warranty deed that named all the siblings, did it include survivorship language?
I don't think so. The only survivorship on there was for my mother.
Awesome. So
She
here's
was
the
able
answer.
to stay in the house since she was not on me. She was able.
Yep, I follow. So you and your siblings are all fractional owners you and your siblings are all fractional owners of the family house. Your late brother's share is going to force the need to open his estate. And Georgia law, if he doesn't have a will, is going to say who his heirs are. If he has a spouse or children, his heirs will not be, all of the rest of you as siblings. I can talk about that with you separately, but I wanted to show you that I know how to do this analysis, but your situation is really specific, and I don't want to speak out of school until I actually read the documents with you. But at least I've given you a really good idea of what's happened so far and what needs to happen. I know somebody else, I think Julie asked, would you please outline the process of how you work with... Go ahead.
When she at the end give us your number and stuff again.
She will, and I'm also going to give her a link, Ms. Evans.
And you give us.
I'm going to give you a link where you can schedule a free phone call with me for 15 minutes. We can go into more detail. The reality is that I'll have to look at the deed with you to answer your question about your brother's share, but I believe that your brother's estate is going to have to be open to deal with his fraction of the house. Julie Alstrom, I want to answer your question. Please outline the process of having your documents, having your office assist in creating the documents we've discussed. I usually meet with clients for an hour and a half to 2 hours as part of the initial consult, usually about an hour and a half. My flat fee for meeting with clients is $350. That's not cheap, but if a client hires me to do anything at all, that $350 applies towards the overall fee. Then I work with that client over the next many, weeks ahead, sometimes a matter of months, in a series of meetings and conversations where we iron out the details of their plan. We review their drafts face-to-face. We answer their questions. We review beneficiaries. We are really sweating all the details because we want you to have a good plan in place. Julie, does that begin to answer your question? Awesome. And as
Yeah.
far as quotes go, I'm a pretty no BS guy. I'm going to give someone a quote at the end of the first meeting or very soon thereafter, based upon what my practice would charge to do things. There will not be surprise billings. I do not bill by the hour. It's flat fee. I put relationships before money. Surprise. That's how you build a great practice. So there's going to be total transparency about all of those details. And now I think Alexandra had a question. Let me ask you to unmute. Go for it.
Hello. Actually, I'm trying to think. I have multiple questions. My father passed away in December, and he had planned. So my mom is still living. She was diagnosed with a horrible terminal disease about 7 months ago, and he had planned to have a corporate trustee, and then an individual, but like a family friend who would be just on the sidelines. Let's say perhaps non-paid because it's a really good friend that has financial background. And he was really there in case the beneficiaries were 3 children if someone got out of line.
Right.
They had said in the trust that if any of the beneficiaries got out of line, that they would just be asked to leave. So he's been forward thinking because, as you say, sometimes it happens. And so where the problem is that this corporate trustee can no longer take the appointment.
The
So
problem is when you open your mouth and said corporate trustee, because when I hear those 2 words, alarm bells go off. And Alexandra, this is very biased of me, but in my experience, corporate trustees do not know the beneficiaries and do not always care. With rare exception, having someone who has, as you said, a good background, who knows the beneficiaries, who's trustworthy, they often do a better job. But why did the corporate trustees say no in this case?
Oh, well, the corporate trustee, this was discussed maybe 8 years ago or 10 years ago, and there was a change in direction.
Yep.
They changed their codes and policies, and so what we actually have in the trust, they can't undertake that. So it is the way it is.
So if I'm picking up what you're putting down, this corporate trustee is saying, oh, I'm sorry, honey, you don't have $1 million or X million dollars in this trust. We can't be in charge of it. Because a lot of trusts say that.
Well, the thing is, what I was going to say is that's not really the problem. I mean, it is the way it is. My problem today now is that we have to push forward, and the trust is in limbo.
Good. I deal with this all the time. So have we found an amazing person or entity that you want to serve as the next trustee?
So the situation is a twofold. I have actually identified a local corporate trustee that, with our unique situation and what we have, that they've made a proposition. The individual that was going to be on the sidelines when this happened, he said, "Ooh la la." This is kind of where I have the questions for you. He said, this is not what I was going to be getting into, and he's kind of scared about liability because, as I understand with the trust, obviously whoever's trustee runs the risk of being sued or whatever, so they need to have some sort of insurance. And so he sort of had
I'm going to disagree a little bit. Trustees who keep decent records and who don't lie, cheat, and steal have a minimal risk of being sued.
Okay. Well, you're answering part of my question then, because we do have, it took many weeks, but this person kind of said, I'd like to help the family. So a legal person actually drew up a sort of contract, which I actually have now, which, I'm reading it and I'm not used to this sort of thing. So this, and this person, I just don't know really where to turn, because the lawyer, I don't know if there's a conflict of interest, but the lawyer came to us through the individual. Now this lawyer is writing the individual's contract, and how do I say it?
So Alex, let me stop you for a second.
Yeah, I don't know how to judge between
I'm noticing 2 or 3 things. Number one, you've talked to professionals. You don't have confidence in their answers because of potential conflict or interest. This doesn't pass the smell test. That's why your instincts are going off right now. any good estate attorney, myself or anybody you're choosing, ought to be able to look at this whole situation and give you feedback on what your options are. You need to find a good trustee. You're working in that direction, but these pieces have to fit together in a way that makes you comfortable and gives you confidence in the administration of the trust, and you're not there yet. So I'm happy to look over it with you. You can talk to any good estate attorney, and he or she can do the same thing, because again, I'm jaded, but I'm not anti-corporate trustee, but I need to be persuaded that this trustee will do a good job and that the numbers actually make sense.
And that the numbers actually make sense.
And that last part gets into what they should be paid and what they're doing. Is it reasonable? That conversation should be held with someone who doesn't have a vested financial interest in what the trustee is doing. And it sounds like that's not the case right now.
Right. Because it's also weighing, is this individual, it's hard to know. I mean, I'm in the situation and we're going to have to make a decision, but there are good reasons to go with an individual and there are good reasons to go with a corporate trustee. And I've kind of done videos and Googled, and to actually even to know if an individual is capable of having duties down the road that I don't really quite know what they are, but I've read what they are, but is this person capable of doing it? So we're going to have to make a decision, and it's not an easy one.
Here's what I've done for you, for Ms. Evans, for others who have questions. In the chat box, I just entered a call scheduling link. It says bettercallpaul.as.me. You can go to that website. You can schedule a free 15-minute phone call with you. And Alexandra and Ms. Evans, God bless you. You both asked some really super specific questions that are about your situation. Does anybody have any big picture questions about anything so far?
Well, power of attorney, you started to talk about it. I'm sorry, I'm here in Paris, actually, so this is where I live. But you talked about power of attorney, and I missed some of that. I know, because we also, this individual is the power of attorney of my mom right now, and I think so I definitely have questions about power of attorney.
So,
I know it was recorded. Is this going to be on replay, or is it just recorded for your use? Or
No. I think that Kaiser will have a copy of this you can go back and listen to. But I want to address two things. Number one, having somebody serve as trustee for mom and having them serve as power of attorney, that's super common to have people serve in the same role. The underlying question, this is where your instincts are kind of, telling you something. Is this person able to do this job, or is this the fox guarding the hen house? And we have to look at how things are structured, who's getting paid to be able to answer that. One thing I will caution you about, Alexandra, you are a U.S. citizen living abroad in France, correct?
more or less, yeah. I
So
mean,
this
I'm a
is
French and American citizen.
Okay, so you're dual. As a dual, as an American citizen, period, living abroad. I had this happen to a client of mine whose son moved to Canada for work a few months ago. An American who's living abroad cannot serve as the trustee of a trust based here in the US. Otherwise, the IRS says the whole thing is a foreign trust and they tax the heck out of it. So there are a lot of little details that any attorney you talk to should be advising you about to help you make your way along this very broken path.
None of the beneficiaries can be the trustee in our family. So there's no question that I would be the trustee.
Okay.
But thank you.
Yes.
I will take that number down for sure.
Yeah, absolutely. So I have two, Miss Evans and Miss Elkins have totally thrown, real juicy curveballs or knuckleballs at me. Does anybody have any fastball questions that are more general in nature that may help, other people with their questions as well? And ladies, I'm not knocking you. I'm just saying that you both have really specific situations. We should talk about those offline because there's a lot to unpack.
Question about real estate.
Yes.
If the real estate is listed in the will,
yes,
it still has to go through probate.
Yes, and this is the confusing thing. A will is just an admit one ticket to probate court. A lot of people think that a will has its own authority, its own little motor to go through. A will, you got to take to, in DeKalb County, I've got to go see Judge Bedelia Hargrove or staff and get her to say, yes, this will is valid. Executor, go forth, carry out this will. If we want to avoid probate, we put real estate into a trust, or if the co-owners are younger, we add survivorship language. Exactly what Mrs. Evans' parents did not have the option of having back in 1955 when Dad bought the house. So these days, for married couples, Survivorship language is a cheap way to avoid probate upon the death of the first spouse. As people get older, especially 70 and beyond, and the risk of mortality are greater, that's when we start talking about putting property into a living trust. Do I have clients in their 30s, 40s, 50s, 60s who have property in trust? Oh yeah, a lot of them. Is that their only option? No. So my job is not to sell you paper. My job is to educate you about your options, explain them, and then you decide what is best.
Well, when my husband passed, we had this survivorship going, and then
And so now the house is automatically yours.
and then I put my son in where he was on the deed.
Okay, let me tell you about that. What year did you add your son to the house?
About 10 years ago.
Awesome. I'm going to pick arbitrary numbers. If I'm wrong, I apologize. Let's say that back in 2012, when you added your son on the ownership of the house is worth $300,000. When you die, 17 or 20 years from now, however long it is, let's say that house is worth $900,000. Your son is going to pay a big chunk of capital gains taxes on the sale price minus the value of his share when he was added to the deed back in 2012. Paul, how do I fix that? My recommendation, I've done this many times, we can remove your son from the deed by him signing the house back to you. We can then put the house into a living trust so that the house will go to your son upon your death with no probate, and it will minimize any capital gains taxes he pays. If the house is worth $850 when you die and $900,000 when he sells, he's only paying capital gains tax on $50,000 in gain, not $600,000 in gain. Big,
Oh, wow.
big difference.
Oh,
So
yeah. Big difference.
I'm going to be a South Georgia boy. Little pissant details like this cost people a lot of money. The job of any good attorney in this situation is to be diligent and ask questions and walk you through your options.
Yes, thank you.
So
All right.
I have a question,
Thank-
Paul.
Yes, sir.
So what you're saying is it would very well be incumbent on all of us to spend a couple of dollars to elicit someone like you to give us all the things that we need to do right the first time so that later on down the line, we don't sell the farm per se.
It would. And Malcolm, let's be clear. I'm not here to sell myself. I'm not the only show in town. There are plenty of good estate attorneys. There are even
Right.
a few good elder law attorneys. What you want is somebody who's going to shoot straight with you, who's able to answer questions in plain English. If you don't hear that, keep moving.
Okay.
Yeah, thank you.
Okay, thank you, everyone, for all of the information. And Paul, you have really informed us with a wealth of information, and you're making all of us think twice about, everything going forward. So once again, everyone, Paul's information is Better Call Paul as Me. So that is in the chat box. That is BetterCallPaul. And I think it went away.
It's still there. So it's bettercallpaul.as, which stands for acuityscheduling.me. But on the slides, which I know Kaiser's going to share, my information is there. It has our address. It has our phone number. So please feel free to reach out. Miss Evans and Miss Elkins, I'm going to consult you two to help me write law school exams for next semester because you two asked some really good detailed questions. I do want to help you, but I can't do it in 5 minutes apiece.
Yes. And I will say, Paul, I think that we're going to have you back for another session. We got to figure this one out because this was awesome. So if you're willing to come back, we would definitely love to have you and invite you back.
No, I appreciate the chance to be here. And the goal is to be helpful and useful for all the attendees. So I hope today was helpful. Thank you for coming out.
Yes, great presentation. So once again, everybody, we'll give Paul a hand clap for this awesome presentation. And I thank each of you for joining us today. Eric will provide you with the information for our next Thriving After 60 series. And then we'll close everyone out and we will send the presentation over to everyone if we have your contact information, okay?
Fantastic. Thank you all so very much.
Thank you, Paul.
Thank
Thank
you.
you. Have a great
Very
evening.
much.
Absolutely.
Thank you,
Yes,
Paul.
thank you. Thank you, Paul. Thank you,
Thank you all
everyone.
so much. Be well.
Au revoir.
Au revoir.
Au revoir.